So good morning, dear colleagues and friends, the team of marathon runners. This is the fifth out of 6 webinars of our summer marathon, labor EU and international labor standards. It's been a month that we've been together running the path along the path of international and EU labor standards and conventions. And today we are crossing 35 kilometers out of 42, so we are almost there. Meanwhile, let me remind you first that last time we suggested that we hit the record, that all labor inspectors from all over Ukraine join us today, as many participants as possible from the government, from employers, trade unions. So we'll see what happens. Hopefully, we are going to meet the challenge. And let me remind you that we're going to provide you with a certification. If you want to have your certificates at the end, you're invited to pass the test that we are preparing. It's going to be modular, so you will have certification for those modules which you pass, either all the 6 or only some of the 6. So Antonia's presentation will take until 10 past 12. Then we will traditionally address a couple of cases for labor inspectors. Then we will have Q&A until 1, and after that we will share information resources that we have prepared for you on labor inspectorate, and after that you will give us feedback for this fifth webinar, and after that at about 1:25 we will wrap up and get ready for the finish, for the final seminar on the 30th. That's it on the introduction, and I pass the floor to Antonia Santos for welcome address, and then we will switch to his presentation on labor inspection. This time, Antonia, you're welcome.
Good morning, everyone. This training module on labor inspection, it's our 5th online training on international and European labor standards. We have been running this marathon since 25th of June, and it will end on 30th of July. Every Thursday from 11 to 1, we have been discussing a lot of issues with you, which are important. They have to do with the labor relations legislation and also with labor inspection in this case. We have already discussed employment relationship. It was our first training module. It was on the 5th of July. Then we moved to the discussion of the employer's obligation to inform workers about the main aspects of the labor contract or employment relationship and to ensure predictable and transparent working conditions. It took place on 2nd of July. Then we had another, the third module on working time that took place on 9th of July. The fourth module was on part-time, and we extended it to include also a very burning issue, which is telework. So that was in the last Thursday. Today we will focus our attention on labor inspection, and then the last module, which will be on the next Thursday, 30th of July, will address occupational safety and health. Well, the main objectives of this summer marathon of online training is to improve the knowledge, skills, and capabilities of the national police decision makers, and also of the national legal acts drafting experts. And in this case, regarding labor inspection, also to improve the skills and the knowledge about international labor standards on labor inspection of the officials of the State Labor Service and also of the Minister of Economy. It is expected that the increase of the in-depth knowledge of these officials on those international and European labor standards may support a better alignment of the national legislation with those standards, as foreseen in the EU-Ukraine Association Agreement. So my challenge is to turn this online training in a discussion as wider as possible, in which we can discuss all aspects of the labor inspection system in Ukraine. I have a confession to make. I am a labor inspector in Portugal. And I've been working with a labor inspection here in Ukraine since 2017, and I'm really pissed. I am because if I was a labor inspector in Ukraine, I would be very, very, very frustrated, and very frustrated because it's important to understand that no matter how good your laws are, no matter how aligned they are with international labor standards or with the European Union acquis, because if you don't have a way of promoting those laws, of informing workers and employers about those laws, of helping them to comply with the laws, and when needed to enforce those laws, well, they are mere pieces of paper. That's why labor inspection system is so important, and that's why international community, and especially in EU, a lot of attention is paid to labor inspection, because they really can help save lives. They really can help workers have better working conditions, and also for the employers, and that might come as a news for you, but for the employers, it's also good because it improves the productivity of the companies, the sustainability of the companies, and the prosperity of the businesses themselves. So let's then start with our presentation, and then of course we will have plenty of time. We will address some cases in order to stimulate the discussion, and then we will move to a Q&A session. So I hope you like it, I hope you participate, and I hope you really find it interesting, and I hope that once you get in touch with these international labor standards, you really feel that something really has to change in labor inspection in Ukraine in order to improve the system of labor inspection in Ukraine. Thank you. So let's start. Okay, so let's move on. So during this presentation, we will ask the question: what is labor inspection? What are the advantages of an effective labor inspection system? What are the main international labor standards on labor inspection? What are the main concerns about labor inspection in Ukraine? And what are really the implications of what we're going to see for policy decision makers and legal acts drafting experts in Ukraine? What needs to be really done in national legislation in order to ensure that really employers and workers can really benefit from an effective labor inspection system? Then we will have two cases in which we can discuss some of the limitations of labor inspection system in Ukraine. And also, after that, we will give the floor to the participants also to discuss in a more open forum whatever questions they might have regarding labor inspection system, either on the international and European arena or in Ukraine. Labor inspection is a public function of the labor administration system that ensures the application of labor and OSH legislation at the workplaces. Its main role is to convince the social partners of the need and also of the mutual interest in observing labor relations and OSH legislation. And he can do that either through preventive measures, educational and training measures, and also, when needed be, through enforcement measures. As you can see on slide number 4, the advantages of having effective system of labor inspection, either in Ukraine or wherever in the world, is that it really ensures the application of the national legislation on OSH and on labor relations. And that is very important. For workers, for one side, it promotes safer and healthier working conditions. And of course, as a consequence of that, the reduction of work-related accidents and occupational diseases, not only in terms of the number of work-related accidents and occupational diseases, but also on the reduction of their incidence rates. Moreover, it improves the labor relations within the companies, within the workplaces, and allows workers to really exercise their rights. And as a result, it improves the well-being and the life of the workers. As for the employers, of course, if workers have safer and healthier working conditions, if the climate within the workplaces is better, they are likely to be more motivated. Employers will be able to attract the best and the most qualified workers and retain them. And also, as their rights are observed, they will likely be more productive. And that, of course, has a huge impact on the improvement of the profitability and sustainability of businesses. Moreover, if the law is applicable to all workplaces indistinctively by an effective system of labor inspection, it means that employers will face fairer competition. They will not have competitors that will be more competitive because they don't comply with the law. No, everybody will comply with the law. So everybody will be on an equal foot in terms of competition. And furthermore, it will grant employers the access to more attractive markets and to more attractive businesses. Because nowadays, there are a lot of requirements when it comes to develop businesses in other countries or to involve in global supply chains that foresees that the employers that are engaged on those markets and on those chains comply with the international labor standards. So if the labor inspection system ensures the observation of the legal provisions, so it will allow both workers and employers these benefits. And what are the main international labor standards on labor inspection? First of all, Labor Inspection Convention number 81, which was ratified by Ukraine on 10th November 2004. And Ukraine also ratified the other Labor Inspection Convention, which is the Labor Inspection Convention number 129, on the same day, on 10th November 2004. Then we have the Protocol of 95, which complements the Labor Inspection Convention number 81. And this protocol was not yet ratified by Ukraine. And basically, this protocol extends the scope of the Labor Inspection Convention number 81 to non-commercial services sector. Moreover, these international labor standards on labor inspection also include 3 referential recommendations. The first one ever on labor inspection, the Labor Inspection Recommendation number 20, which was issued and adopted even before the Labor Inspection Convention 81, and then the recommendations that accompanied the Labor Inspection Convention 81 and 129, which are the Labor Inspection Recommendation number 81, and regarding labor inspection in agriculture, the Labor Inspection Recommendation number 133. And these international labor standards on labor inspection kind of establish a framework that allows or that facilitates countries to regulate labor inspection at national level. And it ensures that everybody, everywhere, has a labor inspection legal framework which is more or less harmonized around the globe. That's the main aspects of this labor inspection international labor standards. However, in Ukraine, there are some concerns regarding the labor inspection system and the way in which it is or not compliant with these international labor standards, because these international labor standards give guidances and set some kind of best practices and on the legislation on labor inspection issues. And ILO constituents that ratified these conventions should apply them and should ensure that national legislation is in accordance and in conformity with the provisions of these international labor standards. However, in Ukraine, and notwithstanding the fact that Ukraine ratified these conventions, the ILO Committee of Experts on the application of the conventions and recommendations made some observations to some aspects of national legislation that are not in conformity with these two ILO conventions on labor inspection, which is a serious situation, and it's kind of incomprehensible taking into account that Article 9 of the Constitution of Ukraine foresees that the international treaties that are considered binding by the Verkhovna Rada of Ukraine should be considered law in Ukraine, and it's a law with reinforced power. But in Ukraine, no matter that the existence of that constitutional provision, there are some legislation in Ukraine, in particular Law 877 and the Decree 823 that substitute the Decree 295 on the state supervision of the compliance with labor legislation. They have a lot of provisions that and imposes restrictions to labor inspection activity, and for that reason, national legislation on labor inspection is not in conformity with international labor standards. We present some examples of such disconformities. For example, Ukrainian labor inspectors, contrary to what is foreseen on these ILO conventions, cannot perform inspection visits by their own initiative without having prior grounds, which are foreseen on legislation, without prior issuance of the respective order, emission of the correspondent certificate, and the register of that inspection visit on the information system. They also cannot widen the inspection visit scope beyond the authorization included in such documents, and they cannot extend the duration of the inspection visit even when the facts seen at the workplace do so justify. They cannot also perform inspection visits at any time of day or night to any workplace without a prior notice. They cannot perform inspection visits when the employer or his representative is not present. They cannot make inspection visits with the duration, frequency, and depthness which they understand it's necessary to ensure the compliance with the legal provisions. They cannot even impose sanctions regarding observed infractions if the employer, once notified, corrects the infringements that they observe. They cannot promote and enforce compliance regarding unregistered employers, which, by the way, are the ones that usually show more higher levels of non-compliance. And they cannot even suspend workers, even in the case of imminent danger to the health, safety, or life of the workers. Other concerns regarding national legislation on labor inspection, and they include, for example, the very wide mandate of the State Labor Service of Ukraine, which has the labor inspection functions in Ukraine. This wideness of the mandate of the SLS compromises the discharge of the labor inspection primary duties and prejudice the authority and impartiality of the labor inspectors in Ukraine. Moreover, the recurrent imposition of moratorias on inspection visits by the government, as there is one placed right now during the quarantine, for example, and like the other one that was imposed for more than 1 year, they prevent labor inspection from discharging their duties. And the duties of labor inspection are not imposing fines. And that's the problem, because labor inspection is seen in Ukraine as some authority that its only objective is imposing fines to the employers. And that is very wrong. As you can see on the international labor standards on labor inspection that I mentioned before, especially on ILO Convention 81 and 129, you will not see anywhere that the primary duties of labor inspectors is imposing fines to the employers. No, it's not. The primary function of labor inspection is to improve working conditions, How? Through the provision of technical advice and information to employers and workers about the best way to comply with the legislation, through the monitoring, control, and enforcement of labor relations and OSH legislation, and through the filling in of gaps observed in the legislation. That are the three primary duties of labor inspection. And that does not necessarily imply the need to impose fines. This view of labor inspection as a punitive state authority is wrong and is misleading, because primary mission of labor inspection is to help employers and workers to observe the legislation and to improve working conditions, because that has benefits for workers. They will have better working conditions, better health, better living conditions. And as for the employers, they will have a better qualified workforce with better health, better productivity, increased qualifications and skills, and more productive. It's both. It's a win-win situation. Moreover, other problems and other concerns with inspection, with the labor inspection in Ukraine, has to do with the lack of inception and continuous training of labor inspectors, with the working conditions and means of labor inspectors in order to discharge their duties, and also concerning the ongoing process of decentralization through the delegation of labor inspection functions to self-government bodies. And especially because local self-government bodies are not under the control and supervision of a central authority. No matter you have a decree like the 295 or now more recent 823, the government cannot tell to a local self-government body to open a delegation of the labor inspection of labor inspectors. He can say no. He can say no. I don't need here any labor inspection system, because there is the separation of powers between the central government and the local governments. They cannot be obliged to open delegations to provide services of labor inspection, and that also this situation generates a negative consequence, which is that you cannot ensure a homogeneous application of the law in Ukraine, because different oblasts and different zones and regions of Ukraine will have different systems of applying the law, and that is not fair, and that is not good. Moreover, local self-government bodies, labor inspectors, do not have the status of civil servants. So it is questionable if they have a statute and working conditions that ensures them independence from changes in government and from improper external influences. Moreover, qualification, selection, and recruitment processes, training and working conditions of government bodies, labor inspectors, are also a problem, because they are not homogeneous. They depend only on the local self-government body policies. So the qualifications can be different, the selection and recruitment process can be different, even the wages of them can be different, the training can be different, or can even not having any kind of training. So these are really concerns about the system of labor inspection in Ukraine. The ILO Committee of Experts on the application of conventions and recommendations issued an observation, or adopted an observation in 2019, especially concerning the application of these two ILO conventions, 81 and 129, on labor inspection. And the situations that were identified by this committee of experts regarding the non-conformity of Ukrainian national legislation with these two international labor standards are presented in this slide. For example, one of the issues that were pointed out by the committee of experts is that the fact that labor inspection should be placed under the supervision and control of a central authority, which is not the case regarding this ongoing process of decentralization. It should be done, I suppose, through the organic growth of SLS, and SLS would have to open delegations and territorial units in more regions of the country, and in that case, this organic growth would ensure that the labor inspection system is placed under the supervision and control of a central authority. Other observation of the committee of experts has to do with the staff, the fact that the staff should be composed by public officials. It means that the status of the officials of the labor inspection system should be of the public servants. And that is not the case, for example, regarding the staff of the local self-government bodies. In addition, the Commission and experts also observed that labor inspectors should be recruited with the sole regard to their qualification, and that is not ensured, for example, on the recruitment process of labor inspectors that are serving within these local self-government bodies. Moreover, they also observed a limitation on labor inspectors' powers to prompt legal proceedings without prior warning to persons who violate legal provisions. And that refers, for example, to the fact that labor inspectors are not allowed to impose sanctions to the employers which practice some infringements if, once they are notified, they immediately correct the infringements. And that is a problem, because that kind of takes back from the system of labor inspection the effect of dissuasion of their actuation. Because if an employer cannot be sanctioned if he corrects the infringements when they are detected by labor inspectors, he will not have any incentive to comply with the legislation, because he always knows that when he practices an infraction, labor inspectors cannot sanction him if he corrects it. So he will be waiting for an inspection visit to do what he is supposed to do, which is comply with the law. And that is a very important aspect. Moreover, other concerns has to do with the staff status, as it is foreseen on these ILO conventions that I mentioned before. It should be the status, labor inspection staff, and the conditions of work should ensure the stability and independence, the stability of employment and their independence from government and from government changes and from improper influences. And that is not ensured, for example, in what regards the labor inspectors of the local self-government bodies. Another very important observation of the Committee of Experts is the limitation of labor inspectors' powers to enter by day at any workplace they believe it's liable for inspection. Along with this one, another one is the limitation of the powers of labor inspectors to enter any workplace at any hour of day or night without prior notice. This is one of the most important powers of labor inspectors. Labor inspectors should be allowed to enter at any hour of day and night without prior notice to any workplace. And this is a prerequisite for the dissuasive power of labor inspectors. They should be allowed to enter anywhere without any prior notice when they see some violation or they expect that is some violation on a given workplace without notifying in advance the employer, because otherwise the employer will correct it just for that time. And then he will continue he will not have any incentive to comply with the law, because he knows that there is no inspections before he is being notified. So he only concerns about compliance when he is notified that he will have an inspection visit. Otherwise, he will not have it. So it means that at night, at the weekends, whatever, they can do whatever they feel like it, because they know that they will not have any inspection visits. Another concern the Committee of Experts is that labor inspectors should be provided with adequate training and necessary material means in Ukraine. Other concerns involve the limitation of labor inspectors' powers to define the duration, frequency, and scope of inspection visits. This is a very important power. Labor inspectors should decide whether an inspection visit takes 1 hour, 10 hours, or 10 days. And it should not be decided on a decree of the government. Why? Because the decrees of the government don't know what happens in each workplace in Ukraine. and to know what happens in each workplace in Ukraine, you have to go there, you have to inspect, you have to see. And the same applies for the frequency of inspection visits. The frequency of inspection visit depends on the particular situation in each workplace, and that is to be decided by the labor inspector. In the scope of inspection visits, it does not make sense to predefine a scope for an inspection visit, because sometimes labor inspectors are going to a workplace to check something, and then when they are there, they verify other infractions, other infringements, and probably some of them much more serious than the ones that led them there. And they should intervene. They should be able to intervene. They should be able to widen the scope of an inspection visit during the inspection visit. They should decide the duration or the frequency of inspection visits, taking into account the situation in each workplace when they are there, not before, not without knowing what is going on. And by the way, defining by a decree the frequency of visits to employers, for employers is good. If they know that they will be visited only from 5 to 5 years, well, they once they have one inspection visit, they know that the next one will be in 5 years, so they don't have to do anything during the next 5 years. And they will worry about compliance with the law when the time comes to be inspected again. What sense does it make? None. Moreover, the committee of experts also addressed the situation of the recurrent moratorias to inspection visits in Ukraine. One example is the current moratorium on inspection visits during the quarantine. My question is, why imposing a moratoria during the quarantine? Why? Is that labor inspectors are seen as someone that are damaging the interests of the employers? No, they are there to help precisely the employers on these difficult times. So this legislation that foresees a moratoria during inspection visits is preventing labor inspectors to help employers when they most need help. Labor inspectors are not there to kill the employers, to kill the business. No, they are there to help. To help what? To help them compatibilize the needs of the workers, to have safety and health working conditions, and to prevent the contagion of COVID-19 within the workplaces with the need of the employers to ensure business continuity. And that can be done. Labor inspectors can play a very important role in helping workers and employers to protect themselves regarding the negative consequences of COVID and ensure business continuity. Moratorias is like a result of the idea that labor inspection is not really helping, and that is wrong. And that are basically the main concerns of ILO regarding the application of the Conventions 81 and 129 in Ukraine. So what can be done in Ukraine in order to improve labor inspection system, to really extend the benefits of an effective system of labor inspection to all workers and to all employees in Ukraine? First of all, to align national legislation with ILO Conventions 81 and 129, as, by the way, is foreseen on EU-Ukraine Association Agreement. First of all, the scope of labor inspection in Ukraine should be focused on the three primary duties of labor inspection. Ukraine should ensure that labor inspection system is focused on three primary duties: to enforce legal provisions relating to conditions of work and the protection of workers while engaged in work, and it means regarding labor relations and occupational safety and health; to provide technical information and advice to employers and workers and their representatives on the best ways to comply with the legal provisions; and to bring to the notice of the central authority any defects or abuses not specifically covered by the existing legislation. In addition, labor inspection should have a scope in terms of sectors of activity that are liable for inspection. That includes industrial workplaces, commercial workplaces, agricultural undertakings, and also activities in the non-commercial service sector. Moreover, it is important to ensure regarding the organization staff and operations of the labor inspection, that it should be ensured on national legislation that labor inspection system is under the supervision and control of a central authority. And that is a concern that was already expressed by the Commission, the Committee of Experts on the application of the conventions and recommendations in the view of the ongoing decentralization process. That should be really addressed, and labor inspection system should be under a central authority that defines the procedures, that define the policies of recruitment, of training, of the needed qualifications, of reporting, of information systems, in order to have one labor inspection system and not as many labor inspection systems as local self-government bodies. It doesn't make sense. Moreover, it should be ensured in Ukraine that the labor inspection have the sufficient number of labor inspectors necessary to ensure the discharge of its duties. When defining this number of this sufficient number of labor inspectors, it should be taken into account the importance of the duties which inspectors have to perform, the material means that they are provided with, and the practical conditions under which the inspection visits are carried out. It is also important to ensure that the workplaces are inspected as often and with the deepness which is necessary to ensure that the legal provisions are effectively implemented and applied to and complied with. And for that, it should be left to labor inspectors to decide the duration, the frequency, and the deepness of the inspection visits. It should not be regulated on a law 877 or on a decree 823. Moreover, labor inspection should be notified the occurrence of work-related accidents and cases of occupational diseases in order to ensure their proper investigation and the identification of the causes, in order to define policies and strategies to prevent them from happening again. Furthermore, on the occasion of an inspection visit, inspectors should notify the employer or his representative and also the workers' representatives of their presence. But note that it should only be done if they consider that such notification is not prejudicial to the performance of their duties. Because if they think that if they notify the employers that they are there or the workers' representatives, it will damage or it will create difficulties during the inspection visit, they should not be obliged to do so. Moreover, inspection work should involve qualified technical experts and specialists in order to foster the enforcement of legal provisions on OSH and to investigate the effects of process, materials, and methods of work on workers' safety and health. In addition, labor inspection also should cooperate with other government services and public and private institutions that perform similar activities. For example, the tax authorities, the social security authorities, the police, the employment services, etc. They should also ensure the collaboration between its officials and of these officials with also employers, workers, and their representatives. Moreover, as already noted, labor inspection should be composed by public officials, public servants, whose status and conditions of service ensures the stability of their employment and their independence regarding changes in government and also from improper external influences. And of course, labor inspection systems should integrate both men and women. Other implications of these international labor standards on labor inspection for policy decision makers and legal act drafting experts in Ukraine is that in what concerns labor inspectors' recruitment requirements and working conditions, they should be recruited with sole regard for their qualifications, considering the duties that they have to perform. it is important to establish what are the qualifications that they might have, what should be the criteria to select them, and to ensure that the criteria is objective and takes into account the duties that they are in charge with. On slide 14, you can also see that they should be adequately training. And that does not mean, that does not concern only the inception training before they being appointed as labor inspectors, but also continuously in order to accommodate changes on the legislation, the appearance of new risks, of new challenges. So labor inspectors require continuous training. Labor inspectors should be provided with local offices suitably equipped and accessible to all people concerned, to employers, to workers, and to their representatives. Moreover, they should be provided with transport facilities that they need to perform their duties. And also, they should be reimbursed of any traveling or incidental expenses that they have to incur with in order to carry out their duties. As for labor inspector powers, they should be allowed to enter freely and without any notice at any time of day or night at any workplace liable for inspection. That is crucial to ensure that they can really effectively discharge their duties. Moreover, they should have the powers to enter by day at any premises which they have reasons to believe that they are liable for inspection. Because otherwise, without these powers, legislation is just mere pieces of paper. They can be spectacular legislation, but without these powers for labor inspection, they cannot be, their application cannot be monitored or enforced. Moreover, labor inspectors should be entrusted with the powers to carry out any examination, test, or inquiry that they consider that is necessary, and especially to interrogate, alone or in the presence of any witnesses, the employer or the staff of any undertaking on matters concerning the application of the legal provisions that are enforceable by labor inspectors. They should also have the power to require any books, register, or other documents which are foreseen on legislation and copy them or make extracts from them. They should also have the power to enforce the posting of notices that are foreseen on legislation, and they should have the power to remove, for purpose of analysis, samples of any materials or substances used or handled at the workplace. Moreover, labor inspectors should also have the power to take steps with a view to remedy defects that they have seen at the workplaces and which they have reasons to believe that present threats to the health and safety of the worker. And in addition, subject to any right of the employers to appeal to to a judicial or administrative authority, they should be entrusted with the power to demand that such alterations are done at the workplaces immediately or within a given time, including the possibility to impose immediate executory measures, including the suspension of works where there is the imminent danger to the health, safety, or life of workers. Well, but with great responsibilities, it comes also great powers, it also comes great responsibilities. And labor inspectors are not exempt of obligations. First of all, they have to have integrity, independence, and impartiality. It means that labor inspectors should be forbidden from having any direct or indirect interest on the employers that are under their supervision. Especially, labor inspectors are obliged to professional secrecy. They cannot reveal, even after they leave labor inspection, any manufacturing, commercial secret, or secret regarding working processes, which they come to know on the course of their duties. This one, they should also keep the utmost confidentiality regarding any complaint. And that means not only keep confidential the source of any complaint, but also they are not allowed, they are forbidden to inform the employer that a given inspection visit is being done on following a complaint. And also, of course, labor inspectors are required to act with the highest standards of professionalism and competency, which of course requires the specific process of their recruitment, as we talked before, exclusively on the basis of their qualifications to the discharge of their duties before they enter labor inspection, and also a considerable investment on the development and update of their skills through initial and continuous training. Moreover, labor inspection, other implications to the Ukrainian police decision makers and legal acts drafting experts resulting from these international labor standards on labor inspection, they include that it should be left to the discretion of labor inspectors to give warning and advice instead of instituting or recommending proceedings. It means that it should be to the decision of the labor inspector on a given situation, in a given workplace, under the circumstances that are observed there. It is for the labor inspector to decide. Either he gives technical advices, either he gives warning, or he imposes sanctions. It's not to be decided on the legislation. Moreover, it should be seen on the legislation that persons who violate or neglect to observe legal provisions enforceable by labor inspectors shall be liable to prompt legal proceedings without previous warning. Moreover, it should be foreseen on the legislation that adequate penalties for violations of legal provisions enforceable by labor inspectors, and in particular for obstructing labor inspectors when they are discharging their duties, shall be provided on the legislation and should be effectively enforced. So it means that national legislation in Ukraine should provide for adequate penalties for the violations of the legal provisions that the labor inspectors are responsible for enforcing, but also national legislation should foresee penalties for the obstruction of the performance of the labor inspectors. And finally, labor inspection system in general, and labor inspectors in particular, have also responsibilities regarding reporting on their activity. Labor inspectors or local inspection offices, territorial units, for example, have to submit to the Central Inspection Authority reports on their inspection activity. This Central Inspection Authority should also publish annual reports on the work and relevant subject matters on the inspection services under its control, in particular including new laws or regulations that are relevant for the work of the inspection services on labor relations, on OSH, or on the labor inspection procedures, staff of the labor inspection service, and relevant statistics on workplaces liable to inspection, number of workers employed on those workplaces, number of inspection visits done, type of inspection visits, number of violations verified and penalties imposed, number of work-related accidents and occupational diseases, their nature and causes, etc. So it is important also to ensure in Ukraine that the national legislation provides for the obligation of labor inspectors and the labor inspection central authority to provide information on a regular basis regarding the work that is being done. And that pretty much sums up the presentation. My challenge now to provide you with two cases that I hope will allow us to discuss some of the requirements of an effective labor inspection system that should be implemented in Ukraine. So the first case is about Mykola. Mykola is a labor inspector of the State Labor Service of Ukraine for more than 10 years. Last Thursday, he was walking nearby his place with his wife around 10 a.m. and he noticed that in a construction site that he was passing by, there was a scaffold of 10 meters high. And he noticed that on that scaffold, that scaffold was not properly fixed or stabilized, that scaffold was not provided with collective protection against the risk of falling from ice, and there were 5 workers working on it, exposed to the immediate and serious risk of falling from ice, which of course could have the consequence killing them. So he decided to intervene in order to prevent the workers from falling from the scaffold and die. So he told his wife to go home, and he headed to the entrance of the construction site. When he arrived there, the employer was at the entrance, so he presented himself. Good morning, I'm a labor inspector. My name is Mikola. This is my ID. Well, my intervention has to do with the fact that you have, well, as you can see, there is that scaffold there. You see the 5 workers that are working on it, and they might fall from the scaffold because there is the scaffold is not properly fixed or stabilized. They are not wearing any personal protective equipment that can prevent them from falling from ice. And in addition, the scaffold itself does not have any collective protective measures to avoid the workers from falling from ice. So the use of this scaffold should be immediately stopped, because otherwise the workers really might fall and die. Well, instead of thanking the labor inspector for noticing that really it could really help, it could really happen, the workers could really fall, instead of recognizing that and saying to the labor inspector his intervention, the employer told him that he was not notified in advance of this inspection visit. The labor, Mikola, did not present him the documentation regarding the performance of this inspection visit with identification of its scope and grounds, and that Mikola, moreover, didn't have the powers to stop any works, even in the event of an imminent danger to the health and safety of the workers. So he will not be allowed to enter on the work. In this case, Mikola he was prevented from performing his inspection visit, so he went home, and he was obviously pissed because really he could not do his job. He could not avoid that an accident might happen at that work site. The thing is that on Monday, this was Saturday. So on Monday, when he get to the office, he received instructions from the territorial unit director to investigate a fatal work-related accident that happened on Saturday at 3 p.m., precisely on the work site that he was at 10. And according to the participation of the work-related accident, a worker fell down of a scaffold and died. So my question to our dear participants is that, considering the international labor standards on labor inspection that we have seen before, and the data regarding Mikola's case, in particular, the need to have prior grounds to conduct an inspection visit, the need to prior register the inspection visit, defining the grounds, the scope, the date, the employer, the workplace, etc., and the need to have an authorization to perform this inspection visit and to give the employer the documentation. The need to prior notify the employer of the upcoming inspection visit. And the Mikola lack of powers to take steps to remedy the defects on the use of the scaffold or to suspend the works in progress, because on that case, obviously, there was the imminent and serious danger to the life, safety, and health of the workers. What do you think about what happened during Mikola's inspection visit? That is my question to you. So please don't be shy. Just share your views with us. What do you think about what happened here when you compare this situation that could easily happen in Ukraine with the provisions of the international labor standards? Thank you. Over to you, Sofia.
Thank you, Antonio. And while you have been presenting the case, we've had some comments on the chat, and let me mention some of them while other participants are thinking, and they will probably come up with more. suggestions. Comment from Olga. She agrees that in case of this imminent threat for health and life of employees, of workers, the inspector should have the authority to suspend the work. Larissa agrees that since the inspector didn't show any documents and was not properly accompanied, he could not hold his inspection visit. There is a comment from Evgenia Marchishin. Antonia, I believe it is interesting and we could comment on that. That is that the worker could refuse do the work that is dangerous for his health. So the worker could disagree to do that. And another comment from Alexander Tishenko. We will have more comments, but Alexander Tishenko writes that actually the inspector could not conduct this visit, but after the accident happened and someone died, then according to Article 6 of law on the foundational grounds of the SLS, this inspection visit could be conducted after the event happened. Again, let me look through the rest of the comments. Now we have many of them. Well, this is a comment from Olga. You should not confuse the notion that the worker has the right to refuse to do something risky with the duty of the employer to ensure due labor conditions, because workers, they are dependent and controllable by employers. Then Sergei says that according to Article 18 of the law on labor protection, every worker is personally responsible for compliance with OSH requirements. Antonia, take that into account, that workers are personally responsible for compliance. Then the situation in Ukraine cannot be approached from the perspective of international standards, because they have not been fully implemented in Ukraine, and it is a realistic situation, a realistic case. But the employer has done even more than as required by the Ukrainian legislation now. Then Valentina says that sure, all international standards and provisions need to be transposed to the Ukrainian legislation. Any other ideas on this case? Let me check. Vasil Andreev says that in this case, the employer acts correctly under the law. So because we have this legislative framework and he did what was required. Ivanova Lyubov says that the inspector could implement preventive activities with this employer. I wonder what you mean, Lyubov, by preventive activities and what could be done by Mykola in that sense. Alexander Sukharukhov says that it was not a working day, not business hours. So the inspector was rather performing his duty as a citizen, civil duty, not official duty as an inspector. Since I see no more comments from the participants, I believe Antonia could give us some feedback on that case. Antonia, the floor is yours.
Дуже дякую. Very interesting comment. So I will address the comments first, and then I will jump into the case itself, if you agree with me. First of all, the comment regarding the fact that the worker could refuse to work, and the comment that Article 18 of the Labor Protection Law states that workers are personally responsible. Let me tell you the following. According to the Occupational Safety and Health European Union acquis, and also according to the International Labor Standards on Occupational Safety and Health, and we will see them on the next Thursday at 11, and I invite you all to be there. There is a very important principle on occupational safety and health, and that is the non-transferable responsibility of the employer to ensure the safety and health of the workers in all aspects of the work. The non-transferable responsibility of the employer to ensure the health and safety of the workers in all aspects regarding to work, not the non-transferable responsibility of the employee. Employees workers have their own responsibilities on OSH. And the first one is to take care of his own OSH and of the safety and health of the others that can be affected by his actions or omissions, and to take care of the safety devices that are provided to him, and to take care of the work equipments that are provided to him, and to report any defects on the work equipment, installations, and the safety devices, etc. But the main responsibility for the OSH of the workers is of the employer, and that one is non-transferable. That is what is stated on ILO Convention number 155 on occupational safety and health in the work environment, and also on the EU OSH Framework Directive number 89-391. And that is a huge, a main principle of OSH that Ukraine has to align with. Regarding the fact that the employer did well according to the national legislation, that's true, and that's why we have chosen this case. But we have to think about it and to understand, was it right? Yeah, it was legal. His performance was legal. But was it fair? Was it fair? I don't think so. I don't think so. Because he could even not allow the labor inspector in, but he should heard labor inspector and implement the preventive measures to avoid that his workers might die. And one of them died. And then only after the worker is dead, labor inspector can act. So what sense does it make? Tell me, what sense does it make? It's rather frustrating. I would be very, very frustrated to be labor inspector in Ukraine. Well, I mean, I'm frustrated with the legal framework on labor inspection in Ukraine, and I'm not labor inspector here. So I can even imagine how the labor inspectors in Ukraine feel about the national legislation on labor inspection. I will be really pissed about it. I'm frustrated and I'm not labor inspector, so I can't imagine how you can feel. So I really want to do something about it. I really do. I really want to help. But we need to work together to align national legislation on labor inspection with these international labor standards. That is fundamental, because a guy died. A guy just died. It could be avoided if the labor inspector had the power to do his job as foreseen on the international labor standards. So it's pretty frustrating. And it's not good also for the employer, because the employer lost an employee, and he could even be the best employee that he had. Now he has to replace it. He has to recruit another guy. He has to train the guy. You see, he has to pay for the damages that arose from the work accident. And probably, I don't know, the work might even be an undeclared work. I don't know. We didn't put this issue on the case. We could have added. This is really frustrating. And as for the comment of Alexander, he pointed out something very important, which two things. It was not a working day, and that reminds me another thing. First of all, the provision of Law 877 that states that labor inspection visit should occur during the working time of the workplace. The working time that is official of the workplace is also a nonsense. Because if I was an employer in Ukraine, well, I would comply with the legislation during the official working time. And when I do not want to comply with the legislation, I would do it after the work time, because I know that labor inspectors cannot perform inspection visits outside of the official working time. Doesn't make any sense, because we know that there is an official time, but workers frequently work outside the official working time. And that work should be liable for inspection. Any working time should be liable for inspection. And by the way, there is another provision on Law 877, which I consider stupid, to say the least. which is the one that says that labor inspection visits cannot occur when the employer or his representative is not there. That doesn't make any sense. Why? Because if I was an employer and I don't want to have inspection visits, I will just not jump into my workplace. I will never go there, and I will never appoint a representative to be there, because in this way, I will never have inspection visits, because they cannot happen if I'm not there, or if my representative is not there. So what sense does it make? None. In international labor standards, obviously, you will not find any provision that states that labor inspectors can do inspection visits at any hour of the day or night without prior notice, except when the employer is not there or his representative is not there. You cannot see it anywhere. So why in Ukraine that provision is on Law 877? Well, it's a good question for the politicians. So as for the case in hand, well, I think it's pretty fair to say that the requirements of Mikola having prior grounds to make an inspection visit, as to prior register the data regarding the inspection visit, as to bring the documentation to the inspection visit, as to prior notice the employer of the inspection visit, does not make any sense, because to comply with that, you would not have the chance to do the inspection visit. You would not have the chance to improve the working conditions at that work site. You would not prevent the worker from dying. So, and that's why these requirements on Law 877 and also on the Decree 823 violate the free initiative of labor inspectors to undertake inspection visits without prior notice at any time of day or night, at any workplace without prior notice, that are foreseen in Article 12(1)(a) and (b) of the ILO Conventions 81, according to which labor inspection should have the powers to enter freely and without previous notice at any time of day or night, at any workplace liable for inspection, and to enter by day at any premises which they have reasons to believe that is liable for inspection. Moreover, the incapacity of Mikola to take steps with a view to remedy the defects that he observed with the scaffold, and also to suspend immediately the works that were in progress, which, as we have seen, present serious risks to the life, health, and safety of the workers, also violate the Article 13 of ILO Convention 81. He should be allowed to tell the employer to immediately suspend those work, or to provide the scaffold with the necessary stability, fixing it well, and providing with collective protection measures. Moreover, the incapacity of Mikola to hold the employer liable for prompt legal procedures without prior noticing, because he saw an noncompliance, he saw an infringement, which is the use of a scaffold that is not properly, adequately installed, and without the protections, the collective protections that it has to have to protect the workers, that are the health and safety of the workers that will be using it. So the incapacity of Mikola to sanction this practice, because the workers were really exposed to the risk of falling from heights, also violates the Article 17 of Convention 81. He should be able to impose a sanction to the employer for that infraction, and he couldn't. He could not even perform the inspection visit. Moreover, the obstruction of the performance of the inspection visit itself should be liable, should be seen in the national legislation as liable for prompt sanction, and should be effectively enforced. For example, in many jurisdictions, including Portugal, for example, the obstruction of the performance of the duties of a labor inspector is not just an administrative infringement. No, it's a crime, and is punished by jail time. Also, in the case that a labor inspector is obstructed to do his job, he can detain the employer or anyone that obstructs his work and call for the police to take him out. Or if the labor inspector is confronted with such obstruction, he can call the police, and the police has the obligation, the legal obligation, to support and to help labor inspectors. Or if labor inspector estimates or foresees that there will be an obstruction on his inspection work, he can ask police to accompany him to the workplace and ensure his safety during the inspection visit. Finally, in several jurisdictions, including in Portugal, the violation of OSH regulations, especially in construction, is a crime foreseen in penal code. And the penalties are usually aggravated by the result. And in this case, if someone dies, well, the employer is really in a lot of troubles. So, and that is basically what I would like to say regarding this case. So, Sophia, I give back the floor to you.
Yes, Anthony, while you were speaking, summarizing, there were quite a lot of comments. Some of them are rather important, so I would not like to postpone them till Q&A session because they will cool off. Let us take them hot. So there were several important comments. Let me share my opinion, and if you think I'm wrong, tell me about that, but hopefully you will agree with me. So many people like Marina and others say that in this situation, in this case, it is important to inform law enforcement agencies. And if they don't do that, this is like criminal inactivity or negligence. On the one hand, yes, but if we apply the model where we have to notify law enforcement agencies, it's like that we delegate the duty of a labor inspector to every citizen, because citizens need to inform law enforcement agencies about these situations. And then again, labor inspectors who are professionals, who are experts of OSH and of other aspects, who knows the requirements of the law. So sometimes in a situation where a lay person would not notice anything, may notice much more. Quite often we have these discussions with Antonia. Quite often we see scaffolding and he says that this is wrong and that is wrong, and like some pictures, destabilization, some risks, while me, who is not an inspector, I'm blind to that. So can we expect that lay persons, usual citizens, will notice the situations that incur risks for health and safety? Then the police, are they adequately trained in estimating the situations and implementing preventive or explanatory work to prevent this kind of situations? I believe it's not the function of the police. Every body needs to be a professional in their own sector or area. So it is important to ensure cooperation, but not to delegate duties of labor inspector to law enforcers. And then Alexander Sukharukhov says that when there is investigation, then it will be decided whether the employer was to blame and there will be criminal proceedings. But let's keep in mind, what is the main objective of labor inspectorate? Is it about punishing someone or saving lives or protecting lives? So if we kind of detect violations and punish everyone, well, that's one level, but eventually that is about long bureaucratic procedures, expenditures from the state budget, from budgets of businesses, but we will not restore lives or compensate for lives of those who die. So what should we be guided by? Saving lives, prevention, explanation, notification to prevent this kind of episodes, because investigation, this is already last resort or last step in this chain of effective response. Antonia, would you like to add something to that? Maybe I said something wrong.
I cannot overstress that the mission of labor inspectors should be improve working conditions. save lives, save the health and safety of the workers, preserve the safety and health of workers. There is nothing more valuable than human life. Nothing, nothing. So that should be the most cherished value ever. And that's why in the majority of the jurisdictions in Europe and around the globe, labor inspectors has the power to suspend works immediately when the life or the safety or the health of the workers are at stake. And why? Because precautionary measures should apply when the value is the human life. The other values, the other interests that are in place have not the same value as the human life. So they should be put aside in order to defend the most important value, which is the life. That is the sense of a precautionary measure, to defend the most important value over the others. That is the sense of it. But if you cannot act, and you have to go to a court of law that will decide that in 2 months, well, the workers will be dead by then. And what is for the labor inspectors to do? An investigation of a work-related accident, a fatal work-related accident. That is stupid. That should be avoided. And the employers would benefit from it, because it's better to prevent a death than then investigate the death and impose penalties to the employers. Even in the interest of the employers, this law should be revised in order to allow labor inspectors really to do their job and to help employers to improve the safety and health of their workers in order to improve their own profitability and productivity and sustainability of their businesses. So, as for the case of Tamara, well, Tamara is also a labor inspector from SLS for over than 15 years. So she received a trade union complaint regarding the lack of safety of a particular work equipment in a winery. Follow the procedure, which is in the law. She obtained the necessary authorizations to perform the inspection visit. She registered the inspection visit on the information system with the date, the scope, the grounds. She printed the necessary documentation. The head of territorial unit authorized. She notified the employer of the inspection visit, and she jumped there. She identified herself. She explained what she was doing there. Of course, the employer was waiting for her. It was very smoothly labor inspection visit. But when she was visiting the work equipment that led to the complaint, she noticed in another section of the winery that in a silo, which is a confined space to store wine, there was some workers carrying out some works with work equipment which was not appropriate for potential explosive atmospheres. She was struck by it, and of course, as any other labor inspector in the world, she jumped there. She asked the employer to come here, and he asked her, and she asked the employer, did you have access the risks to which the workers are or may be exposed with these works, with this type of equipment, which is not appropriate for potential explosive atmospheres? Because really a silo that stores wine is a confined space that probably has an explosive atmosphere, and procedures should be taken in order to ensure the safety and health of the workers that are involved on works within a silo. And she asked him, so did you assess the risks? And what measures did you implement following that risk assessment to prevent those risks? And the employer didn't answer, just said, this area is out of the scope of your inspection visit, which was really surprising to me, at least. So Tamara could not check what was going on there. So she resumed the work of inspecting the work equipment that led to the inspection visit. But meanwhile, a huge explosion was heard precisely on the silo in which she saw people working on with a welding equipment. Can you believe? Inside a silo, that potentially has an explosive atmosphere. So, quid juris? How do you see it? My question is, considering the international labor standards that we have seen on labor inspection, and particularly in the data of this case, particularly the need to have prior grounds to perform an inspection visit, such as a complaint from a trade union, the need to prior register and print the documents and have an authorization to make an inspection visit with a specific scope that cannot be widened, even if the situations that you verify on a workplace do so advise to widen the scope. So what do you think about it? And we can also, this case was designed to stress the stupidity of the legislation not let a labor inspector to widen the scope of an inspection visit in face of situations that he might see there. But it could be also the widen of the duration of an inspection visit or the frequency of an inspection visit. We select the scope, but we could select the time that it takes or the frequency in which Tamara has to go to a workplace in order to ensure that workplace complies with the legal provisions. It could be also the documentation foresaw that the duration of the inspection visit should be 2 days or 15 days. And she sought during the course of the inspection visit that it should take a month. And your law does not allow that. So let's discuss it. I'm looking forward for your comments on this, because really this is the situation in the labor inspection legal framework in Ukraine, and really it has to change, because in this situation there was an explosion and the 2 workers that were working on the silo died. So again, probably the employer proceeds well, as the comments regarding to the previous case. But my question is, it is fair? It is justice? Or labor inspectors should really have other powers in order to protect the health and safety of the workers, and also to protect the employers, because the employer had lost his workplace, has lost his company, because the explosion destroyed everything. Now he doesn't have a business. So my question is, was he protected? No, he didn't. So labor inspectors could protect not only the life of the workers, but the business of the employer. But they couldn't do it because the legislation didn't allow him to do it, and the employer did not let him and did not listen to the labor inspectors. So, Sophia, over to you to get the feedback from our participants. Thank you.
Thank you, Antonia. Yes, we have a lot of comments. Let me go chronologically. Alexander Sukharukov says that, yes, actually, currently, when these are off-schedule inspections, you can only stick with the scope as indicated in the document. However, Tamara informed the employer about risks and hazards. So if Convention 81 were adequately enforced in Ukraine, she could enter and suspend the activities. However, many people also say that Ukrainian reality is different. I mean, theoretically, in this case, she should have acted in a different way and have the respective authority. However, unfortunately, the legislative framework doesn't make it possible for the inspector. Tamara again reiterates the human health and life and health as greatest value. So it's important to prevent this kind of situations, and thus labor inspectors need to act in line with the conventions. But Lyubov Ivanova again reiterates that employer acted as stipulated by law. So he actually acted according to the procedures as set by law. Then Alexander Tishchenko says that if an inspector sees this kind of violation in place and mentions that to the employer, even without official documents, the employer could correct, could improve the situation. However, the law doesn't require that. And again, many participants mentioned limitations set by the Ukrainian legislation. Many people say that safe labor is a successful and sustainable business. We need to stick with that. And in the context of the previous case, but I believe it applies here as well, an important comment is that an inspector in any way needs to act in the framework of the national legislation. Otherwise, they may abuse their duties or violate the legislative provisions. And I absolutely agree with you. Actually, that is why we hold this event, because now we are not speaking about that labor inspectors need to act differently or need to stick with practices or legislation of some other EU countries. No, it is about that the legislative framework needs to set the frame for inspectors to act effectively at the performing their duties. And at the global level, those countries who have ratified ILO conventions, who developed and approved these conventions, they actually set this frame or determined the frame that makes it possible to have an efficient labor inspection. So in order that our inspectors could act effectively, we need to start with our legislation. So I agree with the participants there. At the moment of the explosion, we need to call the police, and then Article 278 of Criminal Code applies. Well, okay, again, we speak about that. We wait while someone dies, and then we start acting strictly or specifically, like investigation and bringing perpetrators to justice. Then inspector had to inform the employer about health risks. Well, okay, any other comments? And we are lagging behind our schedule a little bit, so let's see. Vasil Andreev asks a question which we will discuss in Q&A session. Otherwise, that's it. Antonia, let us summarize and we will switch to Q&A then. Thank you.
Thank you, Sophia. So, as for this case, well, again, the requirements of Tamara, that Tamara should have a prior grounds to perform an inspection visit, such as a complaint of a trade union, does not make any sense when compared to the international labor standards. The same applies because it violates the free initiative of labor inspectors to undertake inspections without prior notice, foreseen on Articles 12(1)(a) and B of the ILO Convention number 81, according to which the labor inspectors should have the right to enter freely at any workplace without prior notice at any hour of day or night, and the same to enter by day at any premises which they may have reasonable cause to believe that is liable for inspection. Moreover, the incapacity of Tamaras to widen the scope of the inspection visit, to extend it to the use of inappropriate equipment in the context of a potential explosive atmosphere, violates the Article 16 of Convention number 81, which foresees that workplaces shall be inspected as often and thoroughly as it may necessary to ensure the effective application of the relevant legal provisions. So she should be able, the national legislation should foresee that she should be able to extend the scope of the inspection visit to include whatever situations that she finds necessary to ensure the application of the legislation. Moreover, when she observed situations that could endanger the life, safety, and health of workers, she should be able to take all the steps in the view to remedy those defects or even that constitute a threat to the health and safety and life, inclusively of the workers, inclusively to suspend the works immediately. She should have the power of imposing immediately executory measures with immediate executory force in order to preserve the life, the health and safety of the workers, because there was a situation of imminent danger to the life, health and safety of the workers. And that violates the Article 13 of Convention number 81. Moreover, the incapacity of the MARA to hold the employer liable to prompt legal proceedings without previous warning following the observation of a violation of OSH provisions also violates Article 17 of Convention 81. And finally, the obstruction of the performance of TAMARA duties regarding the remedy of the situation of using inappropriate equipment in the context of a potential explosive atmosphere also violates the Article 18 of the Convention 81. But let me stress the following. During these cases, we analyzed the performance of labor inspectors and the reaction of the employers in the light of international labor standards. What should be done from labor inspectors and from employers? And we have seen that if both complied with international labor standards, the life of the workers, the health and safety of the workers would be preserved, and also, and this is important to stress, the employers' interests will be safeguarded also. So, as you can see, when labor standards are applied, both parties, employers and workers, benefit. And the problem is that in Ukraine, you have Law 877 and this procedure 823 that are not in compliance with international labor standards. But what really amazes me and surprises me is that you can even have other laws that are not in compliance with international labor standards, like Labor Inspection 81 and 129. But the fact is that your constitution states that international treaties that are considered binding to Ukraine by Verkhovna Rada are law in Ukraine and are laws with a reinforced power. So my question is, why are you applying Law 877 and the Decree 823 when you have a prior law that has more power that is law in Ukraine also? Why? You should that law and that Decree 823 should be considered unconstitutional because they violate the provision of Article 9 of our Constitution that says that international treaties are law in Ukraine. So you have a law already. These conventions are law in Ukraine. These legal provisions that we are talking about since 11 o'clock, they are law already. They are legal provisions that you should observe already. So my question is, why do you not observe these provisions when they are already law? And you choose to observe other provisions, other legal provisions, as the ones that are on Law 877 and on the Decree 823. Why do you choose to observe those ones and not the other ones, and not the ones that comes from the ILO Conventions 81 and 129? That would be the question to the government and to the Verkhovna Rada of Ukraine, because they are law already. So you have to choose: either you apply the Law 877 legal provisions and the Decree 823 legal provisions, or you apply the international labor standards that are already law in Ukraine. And in this case, you don't have, because when it comes to international labor standards and considering the legislative framework in Ukraine, you don't have to transpose an international labor standard to be valid in Ukraine. You just have to ratify it, as you already have done. Contrary to what happens in Europe, when you have a directive, you have to transpose it through a national law. But the international labor standard, you don't need to do so. So they are already law. So you just have to stick to the provisions of the ILO Conventions 81 and 129, and that's it. You don't have to do anything else. So I leave you with this thought. I give back the floor to Sophia Letven to start the Q&A session. Thank you so much for your attention.
Yes, Antonia, we had a very lively, active discussion, lots of comments regarding international ratified treaties and the national legislation and the principles in the framework law 877. In the course of your presentation, there have been several questions and comments, and let me start with them so that the colleagues, there is one question in the course of the case discussion. Somebody asked that, when does the labor inspector in the field can make a decision on whether he or she should use warning or some stricter sanctions? So the question is how to ensure that the inspector is not abusing his powers, like there is some preliminary collusion with the employer, that I give you a warning and that's it. So to avoid this kind of situations. Again, how to prevent abuse of this authority by labor inspector and to ensure that labor inspectors are going to be unbiased when trying to prevent some dangerous situations. Then there were comments from Olga. She agreed that local governments should not have this authority that has been delegated to them by SLS, and that it is very important to have the authority to immediately suspend the work if there is imminent health threat. What else? So far, so good. Let me check the chat box if there are any questions or comments that we have not yet addressed, that have not been verbalized, anything new to what we have already discussed and analyzed. Again, some comments on limitations in connection with the legislative framework. And we have very active inspectors. We have here a lot of comments from trade unions as well, but I believe that it is also important to hear employers in this discussion. It seems to me, maybe I don't know you all, but it seems to me that we have had very few comments from employers. So maybe employers would like to come up with their opinion regarding this discussion and the situation that we have in Ukraine. If so, write in the chat box and we will unmute you if you wish to add to the discussion. I see Alexei Valentinovich raising his hand. We have a lot of people with their cameras on, so try to use the chat for me to see you. Maxim, let us unmute Mr. Miroshnichenko. Good afternoon, dear colleagues. First of all, I would like to express gratitude to Antonio for this very detailed seminar or workshop. I believe it is one of the most successful workshops if we consider the content, informational content of it. I have a lot of questions, as always, to Antonio, of course, but let me focus on just two. When Antonio presented activities and authorities of labor inspections, you mentioned three key functions, prevention, law enforcement, and etc. However, what about analytical functions? Because if we use analysis, if they actually use some modern ICT means, it is probably possible to target inspections better to some sectors or territories. And second, we mentioned that it is important to extend the scope of authority of an inspector. We keep discussing that. But my question is, what about liability of public officials, inspectors, if they cause damage as a result of suspension of production processes, for example? Because we always say that it is important to ensure better balance of responsibilities or liability of businesses and officials. But officials usually, well, they say that there are no funds to compensate some damage, to refund some damage inflicted on the employer. So actually, it is very difficult to ensure some material or financial liability in that sense. Thank you, Antonia, again, and thank you, Sophia, for very interesting workshop.
Thank you to the question of the participants. So, to my mind, I have three questions. One regarding how to choose between applying technical advices and warnings or immediate sanctions. And from Alexei Mirosnichenko, two questions regarding first analytical functions of labor inspection and liability of labor inspectors in case of causing damages to the employers, in case, for example, of suspending works. So let's start for the first question. How to choose when to give warnings or when to apply sanctions? Well, I would say the response to that is common sense. Labor inspectors have a discretionary power to either apply sanctions or to give warnings. Discretionary power is not arbitrarian power. It's discretionary. It means that they can opt for one situation or from the other. And they have to justify their options. When they make a report on the inspection visit, they have to explain why they opt for the warning instead of the sanctions, or why they opt by the sanctions instead of the warning. It's not an arbitrarian power, and it can be checked. So how then to choose? So they should have that power, that discretionary power, but how should they use it? With common sense and experience and training. There is a model that should be considered to use, and we use it in Portugal. The choosing between one approach or the other depends on the situation, on the circumstances of each case that is seen on the workplace, and usually rather easy to explain it, considering the following: the employers do not comply with the law basically for three reasons. One, they don't know the law. They don't know. They need information. They need technical advice because they don't know. In that case, labor inspectors in this case, should provide informations, technical advices on how the best way to comply with the law. And that would be the right approach in that situation. So basically, labor inspectors should adapt and adjust their professional gesture and the application of the legal procedures foreseen in law according to the situation that they see at the workplaces, to the behavior of the employers, and to the reasons of the behaviors of the employers. So in this case, when the employer does not comply because he doesn't know, the labor inspector should provide information, technical advice in order to explain to the employer what he should do to comply with the law. If the employer doesn't comply because, although we know he doesn't have the means to do so, he doesn't have financial resources to do it, the human resources to do it, or the time to do it, labor inspectors should give them time and should give counseling on the best way that he could comply with the law, sharing best practices of other employers, how they solve those problems, giving examples of how he can do it, giving more time for the employer to implement the right measures, the right preventive and protective measures. But there are always also cases in which the employer knows what he should do, he knows the law, he have the means to do it, but he just don't want to do it. Well, in that case, the best approach would be, of course, to enforce it, either by notifications or by sanctions. And that is why it should proceed. The question regarding how to avoid the abuses. Well, that is a very interesting question, and it makes all sense. How to avoid that labor inspectors abuse their powers? As you can ask to the police, to the military, to everyone, to the any other public official, how to avoid that they abuse their powers. First of all, being very careful about the people that you recruit to the labor inspection as to another state service. Selection and recruitment are crucial. First, and as you see on ILO conventions, they have to have the right qualifications to the performance of their duties, and they have to be recruited solely on the basis of the qualifications for the performance of their duties. Also, there should be a very criterious competition, public competition, and selection procedures that should involve tests of knowledge, psychological testing, professional interviews, etc. That is crucial. Moreover, there should be training. Training is very important in order to develop skills and to conform the behavior of labor inspectors with the behavior that a public official that as the authority of the state should behave. Because labor inspectors are there to serve, not to be served, as the other public officials, by the way. And also, labor inspectors don't represent themselves. They are representing all Ukrainians because they are a public authority. The powers that they have are the powers that were given by the people of Ukraine so that it can represent them, not themselves. So, but for that, you should be careful and you should give inception training and continuous training, not only on technical aspects of labor inspectors, of labor inspection duties that are plenty, not only on the laws that are applicable and that are enforceable by labor inspectors, but also on ethics and deontology and professional gesture. That is crucial. And of course, there is another way to do so, which is when a labor inspectors act, they have to report on what they have done, and they have to justify their options. They have to be traceable and they have to be understandable. No one can question if a labor inspector gives a warning instead of a sanction or a sanction instead of a warning. That's true. But labor inspectors have to justify by writing their options, and the options should make sense and should be understandable. Okay? So, as for the second intervention of Alexei Mirosnichenko, to which I extend my greetings for participating in our online training. Thank you, Alexei. As for your questions, yes, labor inspectors have also analytical functions. They are not their primary duties. Remember, the primary duties are the ones that we already discussed. Providing technical advice and information, monitor, control, and enforce legal provisions, and fill gaps on the law. Bring to the attention of the central authority any gaps that they see on the law. But of course, there are other duties, and one of which is precisely the one that you mentioned. And that's why it is foreseen on ILO Conventions 81 and 129, the obligation to report to labor inspection the occurrence of work-related accidents and occupational diseases. Why? Not only because labor inspectors has the legal obligation and powers to investigate work-related accidents and occupational diseases in order to determine the causes of those accidents and diseases, in order to develop strategy and interventions in order to avoid those events to repeat themselves, but also to develop at national level strategies for prevention of occupational risks. But also, labor inspectors are also required by ILO conventions to report on their activities, to report what they are doing, what workplaces they visit, what are the violations that they detect, what are the procedures that they adopt regarding the violations detected, etc., in order to understand the application of the law across the country and to identify potential areas that need a more close follow-up and to devise strategies and procedures and programs in order to address specific problems that those information and data describe. So there is this analytical side of the labor inspection activity, and usually is on the basis of this information that is collected during inspection visits that labor inspection system programs the activity for the next year on the basis of the situation that counter the analysis that they make regarding complaints of trade unions, of employers, of workers. What are the most burning issues? What are the nature of the complaints? What are the number of workers affected by those complaints, etc., etc. The gravity of the situations that are on the complaints, and on the basis of all that information, Central Authority for Labor Inspectors for Labor Inspection formulates plans for the activity of labor inspection for the next year, and then they follow up on the objectives, on the outcomes, on the targets they define for each area of activity, and they monitor the execution of that activity plan. That's the way it should be. So that analytical component of the work inspection, of the work of the labor inspection, is important. And by the way, I suppose 3 or 4 years ago, the OSH Day, promoted by the ILO worldwide, was focused on occupational safety and health data, which is very important because we cannot fight with what we don't know. So when we are addressing labor, for example, undeclared work, it's important to know where are the undeclared workers. What are they? Are they young? Are they old people? Are they students? Are they retired people? Where are the sectors of activity where are the most prone, where companies are most prone to engage on undeclared work? And what types of workers are most prone to engage on undeclared work? And what are the reasons for the engagement of one and the others on undeclared work? Because if we don't know it, we cannot fight it. The same for us. Where are the activities, the work equipments that are used, the agents that are used, the sectors of activity where the work-related accidents occur, the fatal ones, the non-fatal ones, and the occupational diseases. What are the most affected sectors, type of employers, type of workers, in what work schedule they are in. So understanding this allows us to devise more effective strategies and procedures to act. So that is a very important part of the labor inspection functions. But of course, as you mentioned, it requires information systems, very good information system that allows not only collect the data, but also to treat this data. And that is not the case of SLS at this moment. So it should be sought to really develop and implement a more effective and efficient information system for SLS in order to gather this information, treat this information, and help to manage the labor inspection system and provide information to workers and also to employers. Finally, regarding the question of Alexei Miroshnichenko, regarding the liability of the labor inspection. Well, that is a burning issue. It's not just on Ukraine. It's all over the place. And in Portugal, the liability of labor inspection is not different from the liability of other public officials. And there is a legislation in Portugal that addresses the responsibility of the public servants and public agents regarding the damages arising from their decisions. And it establishes what type of liability is that, what are the limits of that liability. And of course, there are several jurisdictions in which the public servants have an insurance for liability. It means that when someone, a public official, takes a decision, a well-intentioned decision, but that proves to be wrong, and that causes damages to third parties, well, that insurance should cover the damages to the third party. That might be a solution on this. But it's important to understand that labor inspectors do what they do not to harm employers. They do what to do to defend the interests of the workers and also the interests of the employers, because the interests of the employers are the interests of the workers, and the interests of the workers are the interests of the employers. But sometimes, even when we think that we are doing well, we might cause damages to involuntary damages to third parties. And in that case, there should be in place an insurance that covers those damages. So, and I think it's all regarding the questions that were addressed to me. Sophia, I give back the floor to you in order to check if there is any additional questions. I will be happy to answer. Thank you so much. Over to you, Sophia.
Yes, Antonia, we do have questions. We see very high level of interest, but we have very limited time. So we need to be very brief. So question 1 from Larissa Melnik. What are models of interaction of labor inspection and trade unions? And this goes in line with other questions. So what's the place and what is the impact of trade unions in the context of inspectorate inspection activities? So to say, how can trade unions complement maybe or enhance functions and activities of the labor inspection? That's one question. Second question, which was reiterated, so let me mention it. There was a comment on the chat box that ratification is where a legal act, international legal act, becomes part of the Ukrainian legislation, while application or implementation, enforcement, that's very subjective. I mean, so the question is, if we adequately understand that an international act of law becomes part of the national legislation, what are the implications, and to what extent are we free to interpret these international provisions? These are two questions. Then Eduard Kainov and another participant, they put pluses in the chat box. What do you mean? Do you want to ask a question or you agree with some of the participants? So if you want to speak now, write slovo in the chat. And there will be another intervention from Olena Konovalova on behalf of SLS. Antonia, you are welcome now, but please try to be brief. The floor is yours.
Okay, thank you, Sophia. I will try to be brief. As for the question of Larissa, what are the models of interaction between labor inspection and trade unions? I will just make 3 comments. One is that it's important to understand that labor inspection is not a trade union, and labor inspection is not an employers association. Labor inspection is not a lawyer of the workers and is not a lawyer of the employers. Labor inspection should be seen as an impartial and equal distant public authority that has only one focus, which is to ensure that the legislation on labor relations and occupational safety and health, whatever that legislation might be, is complied with by both workers and employers. It means that on the relation of labor inspection with both workers and employers, labor inspectors should maintain an equidistant position from one and the other. It means that labor inspector cannot be instrumentalized by workers. Labor inspector is not the armed forces of the workers or of the trade unions. And they should not be also the armed forces of the employers. and should not be instrumentalized by the employers. But that does not mean that they should not have relations with them, and they should not consult with them, and they should not work together. And as you have seen on ILO Conventions 81 and also on the ILO Convention 129, labor inspectors and labor inspection system should work and collaborate with both workers, employers, and their organizations. And how they do that? Well, they can do that through organs within the labor inspection system, as it happens, for example, in Ukraine and in Portugal. There is an organ, which is the consultancy board, advisory board for us, for example, where in Portugal have sit the labor inspector representatives, trade union representatives, and also employers representatives. And we discuss a lot of issues regarding the mandate of labor inspection. But there is an exception on the inspection activity. That advisory council cannot make binding suggestions. That's the only restriction. But also labor inspection also has very good relations and practices of consulting and exchange of information with both workers and employers associations. It's not unusual to have meetings with employers associations and also with trade unions. It's a common practice. But we analyze objectively, for example, when it comes to complaints. We don't have necessarily to run when we receive a complaint of a trade union or a complaint of the employers. We analyze the complaints. We see the number of, first, the credibility of the complaint. Second, the number of workers affected, the nature of the infraction that is denounced on that complaint, and the seriousness of that complaint, because labor inspectors has a pile of work to do, has low resources. They are not enough for the work they have to do, so they are always running. So we have to define priorities. And we have a plan of activities that define what we should do. And besides that, we have the need to have, we have, of course, programmed interventions that are foreseen on our plan of activity, but also labor inspection have reactive interventions. And as for the reactive interventions, they have to be prioritized, and that priority has to do with the number of workers affected, with the seriousness of the offenses, if it is regarding, for example, discrimination or situations of forced labor or child labor or well, situations, serious situations. They are priorities that just have to be addressed immediately, but otherwise they have to be analyzed and they have to be studied. There are in Portugal, for example, in several countries of the European Union, there is no history of inspection visits being done by trade unions, but there are some examples elsewhere. That is not the case in Portugal. In Portugal, labor inspectors do not have to go with to perform inspection visits accompanied by either employers or workers' representatives. No, they can request that if they think it's helpful, but otherwise they are more than allowed to go alone, and that is the common practice. We usually, when we do an inspection visit, we inform the employer that we are there, and we inform the workers' representatives that we are there. But we only do it if we think that doing so will not jeopardize the objectives of the inspection visit itself. Because if we think that it will cause problems to the performance of the inspection visit, we will not do it. We will only do it after the inspection visit is done. But usually the relations are good between labor inspectors, workers, and employers. And why? Because we really keep the distance between one and the other. We treat both workers and employers on the same playing field. We are exempt and equidistance from one and the other. That is very important to be effective. As for the implications of the ratifications versus application of the conventions, well, if Ukraine or other country ratifies international labor office convention, ILC convention, the ILC convention is law on that country. It means that the provisions of those conventions are applicable on the national juridical sphere. As for the application, well, national law should foresee, for example, the penalties for violation of those provisions. Yes, but it cannot define, as it happens in Ukraine, for example, it cannot limit the provisions of the provisions that are foreseen. For example, ILO Convention 81 says that labor inspectors should have the power to visit any workplace at any hour of day or night without prior notice. So national legislation should not limit those powers, because otherwise they will be violating that provision of that international treaty. What they should do is provide for sanctions for the violations of those provisions, or procedures for the implementation of the provisions. But those procedures cannot limit the extent of the provisions themselves, or cannot distort, or cannot misinterpret. That's the carefulness that should be applied when talking about implementation of international labor organization conventions. So, Sophia, I think I responded to the two questions that were mentioned. Of course, if there is any additional question, I will be happy to ask. So, over to you, Sophia.
Yes, Antonio, thank you. So far, we don't have questions. We have a lot of comments, but they are kind of clarified in the course of discussion. And now I ask Maxim to unmute Olena Konovalova from SLS. She would like to offer a couple of interventions. Thank you, Sophia. Good afternoon, dear colleagues, and thank you for this opportunity for myself to add a couple of words. I would like to emphasize what has been done since the beginning of this year in order to, even though we are moving in small steps, but we are trying to do something to come closer to harmonize with those requirements for labor inspectors that are set out in Conventions 81 and 129. Well, I believe that all of you know that back in 2017, with the support of the ILO project, the training course for inspectors was developed. It is an online or e-training course. It consists of several modules. They keep updating this training course. In particular, recently we added a module on counteracting human trafficking for labor exploitation. So it is being developed, and we support the relevance of it. And this year, due to quarantine, due to lockdown, actually, we were able, since we have a certain pause in our activity, we made it possible for all labor inspectors to undergo this training. So eventually, we have 1,500 labor inspectors who have undergone this training, and they successfully passed their tests and they received the respective certificate. That is a step towards enhancing capacity of labor inspectors to implement their duties at certain professional levels, at their respective professional levels. One of the modules of that training course is on training labor inspectors on how to behave in stressful situations, how to avoid conflict, how to try and convince people that it is necessary to implement some measures like corrective measures, which also increases the level of professionalism of our inspectors. Currently, Resolution 823 has been amended, where it is stipulated that it will be mandatory to check, to test the knowledge of labor inspectors. This is done in order to enhance the preparation, the quality of training the inspectors for them to implement their duties, in order that their professional level were in line with those requirements that are set for this profession and for this sector. Well, that's it on my side. And thank you, Sophia, again for making it possible for me to add to the discussion. Thank you, Olena. And let me mention that back in 2018, Antonia prepared a comprehensive analysis of the legislative framework of Ukraine regarding SLS in the light of international conventions, and he came up with a lot of recommendations and advice on how to increase efficiency of labor inspection, both in the legislative level and in the applied technical level. A lot of them are still relevant, and they have been mentioned today in this presentation, in Antonia's presentation. Well, I see it actually as a basis for a roadmap that could be developed and implemented step by step. That could be the list of those activities that could be implemented so that all of us in Ukraine had every advantage of an efficient and useful labor inspection. A lot of recommendations have been prepared, a lot are still in store, and now I will pass the floor to Antonia, because I know that SLS has done a lot of other things to implement those recommendations that we set out in that document. So maybe you could come up with your feedback on the training that was recommended and on merging the functions of labor inspectors and trade unions, and whether, to what extent it could be helpful to improve the efficiency of SLS in Ukraine. And what do you think, Antonia, is the key thing or key factor that would contribute into higher efficiency of SLS in Ukraine? The floor is yours.
So thank you, Sophia. First of all, some comments to what Olena Konovalova has said. Good morning, Olena. Thank you for your contribution. I just want to point out that first, training of labor inspector is really fundamental, and you are going on the right direction. But I have to stress that while you have SLS or labor inspection system under law 877 and on this 823 resolution, labor inspection will not be aligned with the international labor conventions 81 and 129. And let me remind you that is primary duty of labor inspection, in this case SLS, to identify the gaps on national legislation and to propose to the competent authority, in this case, Minister of Economy, the changes that the legislation has to have in order to align with international labor standards. And in this case, I think one of the priorities of SLS should precisely be to create, to align national legislation with international labor standards on labor inspection. Because training is very important, but when labor inspectors cannot do an inspection visit at any time of day or night without prior notice, well, there is no training that will save labor inspectors from not being efficient or effective, nothing. When they cannot decide the scope, the duration, or the frequency of the visits, doesn't matter how trained they are. So the priority should be really to align national legislation with international labor standards and not the other way around. Because the rest is not enough to fill in this distance. Moreover, this resolution 123 is also not in conformity, because it sets out a lot of grounds that should be requirements or pre-requirements to an inspection visit. and they limit the powers of labor inspectors. They impose restrictions to the powers of labor inspectors. So I would say that the priority of SLS should really be drafting a labor inspectors legislation from the scratch that is aligned with ILO Convention 81 and 129. And let me remind you that we are here. ILO is here to help. We are here, and we are very happy to help. And our project, EU-ILO Project, our safe, health, and decent and declared work in Ukraine, has an outcome precisely focusing on developing a legal framework for labor inspection in Ukraine that is aligned with ILO Convention 81 and 129. And my challenge to SLS is join us. Let's get together with also the employers and the workers, and let's draft a legal framework for the labor inspection system in Ukraine that really defends the interests of workers and also the interests of the employers. So let's do that. So taking what, let me just pass the floor to Sophia. She mentioned a study that we developed within our previous project on the analysis and recommendation regarding the legal framework of labor inspection in Ukraine. And I take the opportunity to invite Sophia to kind of surf on our website to show you some additional resources on this issue that we are discussing here, labor inspection legal framework, and in particular on that resource on the analysis of the legal framework of labor inspection in Ukraine, which is on the website of the previous project. Sophia, over to you. Thank you.
Thank you, Antonia. I will try to serve very quickly since you've been with us mostly from the very beginning. You remember the address of our website, ilo.org, and in the component of labor inspection on the right, we can see labor inspectorate, and here we have the new section. There's an online trainings on international and European labor standards, and here you can see the entire batch of documents on this issue. So as usual, the training materials, training proceedings can be downloaded, infographics on the same issues if you have no time to read into every detail of that, but you want to know everything, you can download today's Antonio Santos's presentation here, then all the instruments and tools of ILO on labor inspection. And this is the document actually which I mentioned and which Antonia mentioned. This is analysis of the legislative framework of Ukraine for labor inspection. You shouldn't be diverted by the fact that it is of 2018. It is very relevant today, and it contains a lot of strategic documentation recommendations. You can find all of these documents on our website, and you will also receive today an email with all the links to all of these documents. You are invited to look through that, and if you have any questions, to go back to us. This is it on the resources, so let's wrap up Q&A. And now we have up to 5 minutes to wrap up for Antonia to summarize today's event. And then we say goodbye till next Thursday, when we are going to strike the finish line. Antonia, the floor is yours.
Yeah. So, well, I would say that the main conclusions are that it's obvious that an effective labor inspection system offers clearly advantage to employers, increased business profitability and sustainability, which is based on a more safer, healthier, motivated, skilled and productive workforce. Employers would have fairer competition and access to more attractive markets and more attractive business opportunities. As you know, increasingly to work within several global supply chains, or to have commercial relations with some countries, it is increasingly demanded that the operators comply with certain international labor standards. So the ones that are already complying with those standards are more has more opportunities to engage on these more attractive business deals. As for the workers, well, an effective labor inspection would ensure them safer and healthier working conditions, and of course the consequent reduction of occupational accidents and diseases. It will provide them with better labor relations and the effective exercise of their rights, and also, of course, as a consequence, an improvement of their well-being. Moreover, another conclusion is that, of course, Ukraine ratified the ILO Conventions 81 and 129 that are, according to your constitution, in force in Ukraine. It means that in spite of Law 877 and this resolution 823, Ukraine should really apply the ILO Convention provisions. The ILO Convention provisions are in force, so there is no reason for applying Law 877 or Resolution 1823 when you have a law which is a reinforced power that provides differently. So when to choose between the law to apply, you should apply really the ILO Convention 81 and 129 provisions. And of course, the laws that are not in conformity with this ILO Convention should be revised. And I challenge employers, workers, and also the government to join forces with the ILO, and in particular with our project. We are here to help. We are happy to help you to draft a new legal framework for labor inspection in Ukraine that is in conformity with ILO Conventions 81 and 129. We already discussed what are the main issues and the main concerns regarding the national legal framework in Ukraine. They include, for example, as we have seen, the lack of powers of labor inspectors to discharge their duties. They include the recurrent imposition of moratorias to labor inspection visits, in general, but also to labor inspection visits. The limitations imposed on the duration, scope, and frequency of inspection visits. The lack of working condition and means for labor inspectors to discharge their duties. They also include the current decentralization process of labor inspection functions to local self-government bodies, which are not under the control and supervision of a central authority. And they also include the qualifications in the recruitment process, the training, the conditions, and the status of the labor inspectors that are engaged in labor inspection functions within the local self-government bodies. So we identify the problems. Let's work on them together. Let's improve the legal framework of labor inspection in Ukraine. We are more than happy to help. Because really, Ukraine should align its labor inspection legal framework with the ILO Convention 81 and 129. Not only because that is foreseen on the EU-Ukrainian Association Agreement, but because, and especially, mostly, because that's what Ukraine needs. That's what the employers need. That's what workers of Ukraine needs. So let's do it. So thank you for all for your constructive participation on this online training. We hope to see you on the last one, which will take place on Thursday, 30th of July at 11. And that one will be focused on occupational safety and health. So hope to see you all there. Thank you so much for your participation. Goodbye and keep safe. Thank you.
Dear colleagues, on my part, thank you too for very professional comments and questions, for a very high level of activity. It is very obvious that you are very much engaged. And I wish that we continue working and doing business and complying with the legislation in the conditions that would be predictable and favorable for life, for work, for every normal citizen who deserves all of that. So goodbye and see you next Thursday. We already miss you. Be ready for some surprise next time, because next training is the last training. And before that we did like, okay, one is gone, second is gone, but now I feel a bit sad. Maybe I will start crying next time because it's going to be the end of that, but maybe that will not be the end. We'll see. So see you on Thursday. Have some rest. See you on Thursday.